Compensatory damages are available in contracts and all torts, including strict liability, negligence, recklessness, intentional and unintentional torts. In contract, the purpose of damages is to return the plaintiff to the position as if the contract were performed. The plaintiff does receive the benefit of the bargain, the expectancy interest, as if the contract were performed, and the idea here is to encourage commerce, not to punish and allow for efficient breach, but force the contracting parties to actually honour their promises. The purpose in tort is different. It's really to restore the plaintiff to the position they would have been in as if the tort had not occurred. So in a sense, the compensatory damages in tort are backward looking, returning the plaintiff to the position they were in before, whereas the purpose in contract is forward looking, to put the plaintiff in the position they would be in if the defendant actually executed and performed their obligations under the contract. Nominal damages are designed to vindicate. They are always $1 in the United States. They're available in contract cases and they're available in intentional tort cases. There's no point in having nominal damages available to vindicate in an unintentional or negligence case. So they're available in contract and in intentional torts. Punitive damages are intended to punish and deter. They are available in cases where punishment and deterrence are necessary, such as intentional torts, recklessness with known risk of harm, and strict liability. Punitive damages are not available in contract cases where the courts do not want to deter commerce. They're also unavailable in negligence cases in the tort. Compensatory damages are divided into two groups: general and special. General damages are those generally incurred by all plaintiffs, by everyone who would suffer this type of injury. Special damages are special to this particular plaintiff. In some courts, special damages are not available unless general damage awards have been issued. In contract, general damages are those that are envisaged within the contract itself. Special damages are not envisaged, but they're resulting or consequential from the breach. In a tort case, general damages are pain and suffering and include physical and emotional injury. Special damages in a tort case are direct, consequential and economic, such as the precise costs of medical care for this individual. If you're bringing a case in contract, you can't claim punitive damages, you can't even claim emotional distress. You can only claim for damages that are reasonably foreseeable in the contract. You can use a liquidated damages clause to extend this, but many plaintiffs look to combine tort and contract claims in order to gain access to punitive damages and emotional distress. But the courts don't want to turn each contract case into a torts case. The idea when bringing a contract case, if you want to try and gain access to punitive damages, is to include tort claims that can be claimed in parallel within the same pleading, and then you can aim for punitive damages to be awarded as a result of the tort, the duty, the breach of duty and so on, instead of trying to claim them under contract where you will never win. The court will not award damages that are speculative or uncertain. Using a certainty principle, the court will award damages where there is a sound basis for measurement, but they will not award damages where they're too speculative. However, absolute certainty is not required. Certainty as to any losses is fatal to recovery, but uncertainty to the exact amount is not. The court will estimate where necessary, as long as it knows that the losses are reasonably certain to have taken place. The new business rule denies recovery for lost profits for startup companies where there's no history. But this is not always the case, and different courts differ on how they address this issue. Does the court offset the award of damages against the insurance claims or charity that have been provided to the defendant? The answer is no. Under the collateral source rule, the insured status of the individual is not disclosed to the jury. Double recovery is possible, and no, without an offset. The argument is that the individual may have been provided with funds from a relative or from a third party in order to help them through the period of injury until the court case was heard, and that the injured party would likely be forced to pay that money back. So there is no offset. However, in medical cases, the tort reform movement has eliminated the collateral source rule in medical malpractice cases, so the individual that has recovered from insurance cannot claim double recovery from the or the recovery from the medical practitioners for malpractice is offset by the insurance premium and insurance payout that the plaintiff has received. Offset is allowed in certain situations, and it is a defense against damages. For example, an unwanted pregnancy can trigger a medical malpractice suit, but the life of the child and the positive benefits of parenthood can be offset against the lifelong costs of bringing up a child. Another defense is the duty to mitigate. Avoidable consequences, if the consequences and the costs can be avoided, then they should be. And so the damages are offset by a lack of mitigation. If the plaintiff did not mitigate, reduce the damages when they could, they will bear the costs of that, in that the judgment will be offset to that amount. This is an important concept in contracts, mitigation, and a personal injury patient should, when considering mitigation, the question is, should they take the medical action if they're not sure that the medical procedure will be successful? And the test really is a reasonable patient test. Would a reasonable patient undertake the treatment? And that's the test used to see whether the personal injury plaintiff has effectively mitigated when they should have. Is there a cap on punitive damages? The answer is yes. Of course, in contract cases against the government and unintentional torts, punitive damages are not allowed at all. When they are issued, they must be reasonable and proportionate. Otherwise, it constitutes a taking without due process of law in violation of the Constitution. The US Supreme Court recently looked at this and said a ratio of 4-to-1 or single digits is generally okay, where punitive damages are less than 10 times those of compensatory damages. In certain cases where the situation is very egregious, that more than 10 to 1 may, in fact, there are cases with 100,000 to 1, where $100,000 in punitive damages was awarded and $1 in nominal damages in a trespass case. So the court really looks at what's reasonable, and there are three elements to this, three prongs to this analysis. The first one is the degree of reprehensibility. What did the person do that requires so much punishment? Second issue is the disparity of harms. Which side was harmed the most? Was the harm even, or was one side harmed significantly more than the other? And the third prong is comparison with criminal penalties. So if a criminal penalty provides a fine, the court will look to that fine to see what it is when assessing the punitive damages. The purpose of damages in a personal injury suit are to compensate the victim and to punish the tortfeasor where appropriate. These cases do not result in monthly payments to the injured party, but rather a single lump sum award that covers general special damages incurred in the past and those that are likely to be incurred in future. So the general damages in a personal injury suit are those generally suffered by people that are injured: pain and suffering, emotional distress, and the loss of enjoyment of life. The calculation of these issues can be very difficult. Some courts allow a per diem award, like $50 per day, but others don't. Depends on the jurisdiction. Special damages in a personal injury suit are partly made up of past medical fees and expenses, future medical fees and expenses, and also the lost earnings and the lost earning capacity of the injured party. There are some caps under the state tort reforms that cap these damages in states today.